Good afternoon, folks. My name is Daniel Alper. I am a staff attorney at Housing and Economic Rights Advocates. We're a nonprofit legal service organization based in Oakland. We offer free legal services to folks related to general debt and credit issues. And I work on the Homeownership Preservation team, helping folks to avoid foreclosure. And so that's going to be the focus of our presentation today. Is foreclosure prevention work. We will emphasize issues that come up in the context of homeowners associations and property tax issues as well. So let's begin. And by the way, you're welcome to drop your questions into the chat box, and we'll answer them as they come in. Stephen will alert us to questions that come up. All right, so getting started here, what are the housing expenses that can become a risk of foreclosure? Well, of course, there's the mortgage, the regular monthly mortgage payment. There is a difference between, conventional mortgages with a monthly payment and reverse mortgages, some significant differences. So when we're talking about a mortgage, for most of the presentation, we're talking about a conventional mortgage where the homeowner is making a monthly payment. We will talk a little bit about reverse mortgages later in the presentation. And so when you're dealing with a mortgage, it might be the first lien against the property, the first mortgage, often used to purchase the property, purchase money mortgage. And in some instances, you'll be dealing with a subordinate lien, a second mortgage. It might be a HELOC, a home equity line of credit. And the legal protections that are available for first liens under the California Homeowner Bill of Rights are more expansive than those that are available to second liens. So just keep that in mind as we're moving through the presentation, that nuance, that difference between first liens and second liens, second mortgages. Also, property taxes. Those are paid in 2 installments, one in the fall, one in the spring. And of course, property taxes, when homeowners fall behind, those can also become a risk of foreclosure. An item that is paid through property taxes that is important to take note of are PACE assessments. PACE is Property Assessed Clean Energy. It's a financing program for energy efficient home improvements, such as solar panels, energy efficient HVACs, and things like that. And so with PACE financing for home improvements, the financing is repaid through a line item on the property tax bill. And so we've seen cases where folks' property tax bills increase significantly after they enter into a PACE financing agreement. I've seen situations where someone was paying less than $700 per month, per year for property taxes. And then after they took out PACE financing, the property taxes went up to over $6,000. So we have seen a lot of cases where PACE causes trouble for homeowners. And so that's another item to be aware of if there is a PACE assessment against the property. And you can find out if there's a PACE assessment by looking at the property tax bill. There will be a line item for the PACE program. And there are also records in the county property records. There's a notice of the assessment that gets recorded against the property. It may also be referred to as a notice of special tax lien. And so looking at the county property records is another way to identify whether there's a PACE assessment. Homeowners insurance can become a risk of foreclosure really only in the context of a reverse mortgage. When a homeowner has a reverse mortgage, the homeowner has the obligation to keep current the property taxes and homeowners insurance. And so if the homeowners insurance is not kept current, then a reverse mortgage lender can initiate foreclosure. In the context of a conventional mortgage, however, homeowners insurance is generally not a risk of foreclosure. What can happen if the homeowner does not have insurance or does not have sufficient insurance. If it doesn't comply with the terms of the note, for example, then the lender can do what's called forced placed insurance and basically take out an insurance policy for the property and bill the homeowner through an escrow account. So escrow accounts can become a risk of foreclosure especially when there is a deficiency in the escrow account. An escrow account is an account typically held by the mortgage servicer, the company that is servicing the loan for the homeowner. Keep in mind, oftentimes the loan servicer is not the lender. It's a separate company that has the responsibility of accepting the homeowner's payments and applying them to the loan and things like that. And so if the servicer has an escrow account where they're paying the property taxes and the insurance, and suddenly there's a significant increase, like for example, if a homeowner has a PACE assessment against the property and they have an escrow account with their mortgage servicer, then what can happen is that monthly mortgage bill can increase significantly as a result of the deficiency in the escrow account, because there's suddenly this new expense that wasn't there before. And so if a homeowner has an escrow account, that's another thing to keep note of. HOA, homeowners association, condo fees. Homeowners can be at risk of foreclosure if they don't pay their monthly assessments. We'll get a little bit more deeper into homeowners associations later. Just keep in mind, most of these foreclosures that we're talking about here are non-judicial foreclosures, right? They happen outside of the court through a process of recording documents and sending notices to the homeowner. HOAs do have the ability to do either non-judicial or judicial foreclosure, but the vast majority of foreclosures that we see in California are non-judicial foreclosures happening outside of the courts. Maintenance and repairs can become a risk of foreclosure in certain instances. For example, if the contractor is unpaid and records a mechanic's lien against the property, the contractors do have a right to seek payment through the mechanic's lien process. That is a judicial foreclosure, so it happens in the courts. And there are very strict requirements that contractors have to comply with when using the mechanic's lien process. And so it's always a good idea to make sure that the mechanic's lien was in compliance with the statutory provisions that apply to mechanic's liens. It is, strict compliance is required. If the contractor does not comply with those lien procedures, then it may be an invalid lien. And PACE assessments as well can be a risk of foreclosure. If the property tax collector is foreclosing, that happens through non-judicial foreclosure. And so outside of the courts. However, if the PACE, if the entity that holds the right to receive payment for the PACE financing, typically that entity is referred to as a joint powers authority. It's a sort of public agency. If the foreclosure is initiated by the joint powers authority, then that is a judicial foreclosure. So that would happen through the court. So essentially, bottom line, PACE assessments can result in either a non-judicial foreclosure by the tax collector or a judicial foreclosure if by the joint powers authority, the counterparty in that PACE financing agreement. All right, so let's talk a little bit about the non-judicial foreclosure process. Keep in mind, mortgage lenders can foreclose without filing a lawsuit. It's this process of recording documents in the county clerk recorder's office and sending those notices to the homeowner. And so under the Real Estate Settlement Procedures Act, for most mortgage lenders, the minimum amount of time that must elapse from the date of default to that first foreclosure notice is 120 days, right? 4 months. And so the date of default for mortgage is after that grace period elapses. So for when you're looking at a homeowner's mortgage statement, you'll see that it will often say the payment is late after, you know, this 15-day grace period. And so that's the date to consider for the date of default. So 120 days after that, the mortgage servicer, the lender rather, can cause a notice of default to be recorded. It's the first notice in the foreclosure process. And there are strict requirements that the notice of default has to comply with. And I would direct folks to the Homeowner Bill of Rights to learn a little bit more about what those requirements are. You can check out California Civil Code section 2924. And so after the notice of default is recorded, the homeowner has 3 months to work out a resolution before a notice of trustee sale is recorded. In that 3-month resolution period, it's a good idea for the homeowner to reach out to the loan servicer and see what their options are to avoid foreclosure. Typically, this requires submitting a loss mitigation application to the mortgage servicer. And often the requirements for a loss mitigation application will be on the mortgage servicer's website. But sometimes there are specific requirements for the loan, the particular loan at issue. And so it might be a good idea to call up the servicer before submitting a loss mitigation application to ensure that all required documents are in the loss mitigation application before submitted. So after the 3-month resolution period elapses, that's when the mortgage servicer can record a notice of trustee sale. After that, the servicer needs only wait 20 days after the notice of trustee sale to hold an auction and sell the property to pay the outstanding debt. And so keep in mind that after a sale happens, the former homeowner is now treated as a tenant. And so tenants' rights apply. The new owner can't just lock the homeowner out. They have to go through the eviction process and provide, you know, a notice to quit and comply with all of those procedural requirements for an unlawful detainer. And at that stage of the game, it can be a good idea to attempt to negotiate a cash for keys deal with the new owner. That can be helpful to, of course, avoid the ordeal of litigating an unlawful detainer. It can also be helpful, you know, to support the former homeowner on their path to relocation if they can arrange for a cash for keys deal. And it can also be a good way to decide upon a date for moving out that works for the homeowner. Although if the unlawful detainer case goes through the courts, often judges will allow for extensions for the homeowner to vacate the property after, you know, a final order is issued to vacate. Judges will often give extended periods of time for that to happen. All right, and so what are a homeowner's options to avoid foreclosure, right? When we're talking about a mortgage, well, one option that a homeowner has is to refinance the loan. That option. So refinance means taking out a whole new loan, so that the old loan is replaced by the new one. That will, you know, the homeowner, of course, will be current. They're starting fresh with this new loan. Unfortunately, that is not available if the homeowner is already in default, or, you know, if there are pending foreclosure proceedings. That's, of course, because when a homeowner falls behind on their payments, they're going to get reported to the credit reporting agencies. You know, there's going to be that those negative trade lines on the homeowner's credit report. Great resource to look up a credit report for consumer clients is annualcreditreport.com. Great resource to obtain a free copy of the homeowner's credit report to see, you know, what's reported. And so when those negative trade lines appear for delinquent payments. Lenders that are considering the homeowner for refinance will see that, and that will typically deter lenders from being willing to refinance the loan. They can already see that the homeowner is having trouble making their payments, that they've fallen behind. And there's limited availability for a refinance if the property is underwater. Underwater means that the value of the home, the market value of the home, is less than the outstanding debts against the property. And so if the property is underwater, then that can in some instances deter a lender from being willing to refinance, because if the new loan is, if the homeowner is seeking a loan that exceeds the property value, that is a sign to the lender that they might not be able to, recoup their investment in that loan. If the homeowner eventually falls behind, foreclosure would not be an adequate remedy for the creditor. And so if the property is underwater, refinance might not be achievable. All right, so yeah, jumping into reinstatement, as I just mentioned, reinstatement means paying the amounts that are owed up until that point, the amounts that are in arrears. It does not mean paying off the loan in full. Of course, when the loan goes into default, there will be late fees and, potentially foreclosure fees as well that are tacked on to, to that, to the balance of arrears. And so, all of those amounts do need to be paid in order to reinstate the loan, to bring it current. A reinstatement can happen up until 5 business days before a scheduled foreclosure sale. A complete payoff could happen anytime before the foreclosure happens. And of course, we know that in many instances, folks are not able to reinstate. The reason why they fell behind in the first place, they had some sort of financial hardship that prevented them from making their payments. So it's often not going to be an option, but especially if the homeowner is eligible for reinstatement assistance, for example, through the California Mortgage Relief Program, which we have a link for later in the presentation, or if they're eligible for Alameda County Anti-Displacement Assistance. It's a grant that's available through the Alameda County Anti-Displacement Program, up to $30,000 for homeowners who can, show that they had a financial hardship that led them to fall behind, and can also show that if their arrears are paid in full, that they would be able to afford their payments moving forward. Then, that homeowner here at Alameda County may be eligible for anti-displacement assistance. Which department do you find this? So HERA administers the question we had was who administers the Alameda County Anti-Displacement Program, and HERA, Housing and Economic Rights Advocates, we do process those applications. So, if there is a homeowner who's interested in that program, they can definitely reach out to us for further information. A repayment plan. So a repayment plan means that the homeowner is going to have to be able to afford their old monthly payment plus some more to be able to repay those arrears. So it's basically when a repayment plan happens, the mortgage servicer takes the monthly payment, adds a little bit more over a set period of time, right, to cover those arrears. So just as an example, if the homeowner is $5,000 behind, right, those are the arrears. Maybe the mortgage servicer is going to add $500 a month for 10 months on top of the original mortgage payment through a repayment plan. So when evaluating a homeowner for their potential eligibility for a repayment plan, they'd have to be able to afford their old payment plus some more. A forbearance for temporary hardship. This is a temporary resolution of forbearance. It's not a permanent solution, but it can be helpful, especially if there's a temporary financial hardship where the homeowner became unemployed for a limited amount of time, or they had their hours drop, something like that. Going on a forbearance, right, a period of time where the homeowner does not need to make their monthly payments. They aren't forgiven, of course. They're forborne. They're not forgiven. So they do eventually need to be repaid. We'll talk about what folks' options are post forbearance a little bit later on. Loan modification. Loan modification is where the arrears are recapitalized into the principal balance. The loan is recast over a new term, and ideally the homeowner has a lower interest rate, and that's going to translate into a lower monthly payment as well. Typically, homeowners need to show that their income is about 3 times what the new monthly payment would be for most proprietary modifications. And so again, the homeowner is going to have to submit documentation in their loss mitigation application to prove that affordability in order to be eligible for a loan modification in most instances. In some cases, there might be litigation if, for example, the loan, violates some provision of the of the Real Estate Settlement Procedures Act, or it's implementing regulations. Or if there was some, instance of fraud or other unlawful conduct by the lender, maybe there's going to be a lawsuit, and a victory in the lawsuit could yield the financial relief that's necessary to bring the loan current. And so those are generally the homeowner's options to keep the home when the loan goes into default, when foreclosure starts to happen. And so let's talk a little bit more about forbearance. So it's either a reduction or a suspension of payments for a set period of time. These were widely available to federally backed mortgages under the CARES Act during the COVID-19 pandemic. The deadlines to apply for those COVID-19 forbearances have pretty much expired at this time. You can always apply for a forbearance with Fannie Mae or Freddie Mac loans. But in any case, if folks are still in a COVID-19 forbearance, there are special post-forbearance options that are available to them. We're not going to dive too deep into that during this presentation, just because, again, most COVID-19 forbearances are closing out at this point, and the application deadline has expired for most of those COVID-19 forbearances. But that's another good fact to identify, is whether the loan is in fact in a COVID-19 forbearance, because the post-forbearance options are different under those circumstances. Keep in mind that if there is an escrow account, the lender is typically going to keep paying those amounts even while the loan is in forbearance. But if there is not an escrow account, then of course the lender does not pay the property taxes or insurance. And so while the loan is in forbearance, the homeowner who does not have an escrow account in their mortgage is going to need to continue keeping current their property taxes and insurance to prevent, falling behind on those items as well. All right, so post-forbearance options are almost the same, pretty much the same as your traditional loss mitigation options. Reinstatement, you can pay the foreborn amounts in full. Often that's not going to be an option, but again, folks are eligible for some sort of assistance, especially, that might be more feasible. Repayment plan, adding the foreborn amounts and installments to the regular monthly payment. A deferral, so this is essentially a balloon payment, right? All of the interest and principal and escrow advances are put into a lump sum and put at the end of the loan. They're due at the end of the loan. It's essentially a balloon payment. You'd also get a modification. Again, so often the deferred amounts are non-interest bearing. In most instances, what I've seen is that the payment deferral does not bear interest when it's at the end of the loan like that. That may be different for some private lenders. And so modification, right, that's taking the principal and interest, recapitalizing it into the principal balance, and it's with a target reduction in the monthly loan payment. There's also partial claim or mortgage recovery advance. Essentially, the loan insurer pays the arrears and it becomes a subordinate lien against the property that would, again, typically be due when the loan matures. And so the partial claim, that's particular to FHA, VA, and USDA loans. Just keep in mind that repayment options at the end of the forbearance vary depending on what the investor restrictions are. And so the best way to find out what the homeowner's repayment options are after forbearance is to send a request for information under the Real Estate Settlement Procedures Act. Sending a request for information, also referred to as RFI, sending an RFI to the mortgage servicer asking explicitly whether there are any restrictions on loss mitigation options that apply to this particular loan. Few more points to keep in mind for loan modifications. If the home is in default, that actually often puts the homeowner in a better position for a loan modification, because if the loan is current, what the mortgage servicer sees is that, okay, this homeowner is not having trouble making their payments, they are current, and so why do we need to, modify the terms of this loan? For some loans, the imminent risk of default standard applies, and so even if the homeowner is not in default, if their financial circumstances put them at imminent risk of default, then maybe the servicer is going to consider them for a loan modification. If the home is underwater, that's also going to be a factor in favor of modification. That's because if the home is underwater, the outstanding mortgage balance is more than the value of the property. The creditor is not sure whether it's going to recoup its investment through foreclosure. It might come short because the home is underwater. And so if the home is underwater, that may put the homeowner in a better position to achieve loan modification. By contrast, if there's a significant amount of equity in the property, the creditor says, well, great, then we were much more likely to recoup our obligation, recoup the investment from a foreclosure. And so if there's significant equity in the property, that may hurt the homeowner's chance of obtaining a loan modification. It's not necessarily a deal breaker, just some factors to keep in mind in terms of gauging expectations on whether a loan modification is available. Sustainability. This is underlined because it's pretty much the overriding factor. If a homeowner cannot demonstrate with documentation they can afford their monthly payments after the loan is modified, then the mortgage lender is likely not going to grant a loan modification. In some instances, for those COVID-19 forbearances, there are streamlined modifications where the homeowner does not need to submit a complete loss mitigation application. And so if it's a COVID-19 forbearance, then the fact that sustainability can't be proved on paper might not be a deal breaker. But in most instances, if the homeowner does not have, documentation showing income, typically 3 times the overall debt that the homeowner is paying on a monthly basis, then they're not likely to achieve loan modification. Also, who's the mortgage servicer, who's the investor? Again, private lenders have different rules for when they're going to allow a loan modification to happen. And so always a good idea to submit that RFI to find out what those restrictions are. Keep in mind, under California law, the loan modification application has to be submitted at least 5 business days before the scheduled foreclosure sale to be evaluated. The loan modification application must be complete. Right? It has to have all the documents that the lender requires to consider the homeowner for modification. And so it's a good idea to get that application in, of course, as soon as possible, because there's often a back and forth with the servicer. Oh, we only have, 1 bank statement. We need the 2 most recent bank statements. Or, it's been 30 days since, this particular document was submitted, and so we need a new one. There can often be a little bit of an elongated process of back and forth between the servicer before they say, all right, the application is complete, we'll go ahead and review it. And so really important to get that loan modification application in sooner rather than later, at earliest opportunity. Dual tracking. That means that the lender moves forward with foreclosure while there is a complete. So if a complete loan modification application is submitted, right, for a first lien mortgage, keep in mind the homeowner bill of rights applies to first lien mortgages. And so sometimes second liens are protected as well from dual tracking under federal law, but there are some exceptions. Like, for example, there's an exception for HELOCs that says that HELOCs don't get the the RESPA protections under Regulation X. But anyhow, if the loan is a first lien, then for sure, dual tracking is prohibited. And so if the homeowner has a complete loss mitigation application on the books with the servicer, and yet they move forward with foreclosure, it's dual tracking, and that's unlawful. And so you could submit a complaint to the Consumer Financial Protection Bureau, CFPB. You could also submit a notice of error to the loan servicer, letting them know that this is dual tracking, that, they should be evaluating the loan modification, not moving forward with foreclosure. So always important to keep track of what's happening with the loan after a complete loss mitigation application is submitted. If there's a complete application and then the lender goes ahead and records a notice of sale, for example, that would be a clear violation of dual tracking. All right. And so bankruptcy, real quick note on that. So if a homeowner is going to look into bankruptcy as a means to avoid foreclosure, should really talk to a qualified bankruptcy attorney. Just on the side here, HERA, we do not practice bankruptcy law, but we do refer folks to bankruptcy attorneys in some instances if there aren't really any other options. And so bankruptcy can be helpful because there's the automatic stay on debt collection that kicks in. As soon as that bankruptcy petition gets filed, there's an automatic stay on debt collection, meaning that the lender cannot proceed with foreclosure. And so Chapter 13 bankruptcy can be helpful for establishing a repayment plan. Chapter 13 is essentially a court-ordered payment plan to catch up on the arrears. Just keep in mind that the lender can ask the bankruptcy court to lift the automatic stay on debt collection to proceed in foreclosure. But if it's a Chapter 13 bankruptcy, as long as the homeowner stays current on their payments, then that should not happen. They should be allowed to continue making their payments under the plan. And of course, bankruptcy can have a significant negative impact on credit. Chapter 13 stays on the credit report for 7 years. Chapter 7 bankruptcy stays on the credit report for 10 years. And so it can really hinder folks from obtaining credit later on down the line. And so we would not recommend bankruptcy unless there's absolutely no other option to avoid foreclosure in that instance. Rights of survivors. All right, so under the Real Estate Settlement Procedures Act, lenders are required to maintain communication with folks who are eligible to be successors in interest. These are typically, surviving spouses, children who inherit the property by will or trust. There may be some, a joint tenancy with rights of survivorship. If the surviving spouse or child, inherits the property in that way. As a result of the death of a joint tenant, then under the Real Estate Settlement Procedures Act, they're protected. The lender is supposed to maintain communication with them, accept their payments, allow them to apply for loan modification, and the like. Typically, the lender is going to need proof that the person qualifies as a successor in interest. That's going to require submission of documents such as a death certificate, a deed showing that the property was held in joint tenancy. If the transfer was by trust, then a copy of the trust, or a will if the property passed by will. And this is one of the reasons why we always recommend to folks to have an estate plan in place, because if there is not a will, trust, or a joint tenancy set up, then it can be very difficult for folks to claim the property when it goes through the probate process. And a lot of the time, the probate fees, can eat away at the equity in the home, such that there might not be a home to inherit as a result of all of those court fees. And so HERA offers estate planning services on a sliding scale, so folks can come to us for that. Just in general, always a good idea to have an estate plan in place to avoid loss of the home when when the owner passes away. All right, let's transition to talking about homeowners associations. So here are the common players in the HOA, mostly the homeowner is going to be interacting with the property management company, right? That's the company that manages the property on behalf of the board of directors. The board of directors are the elected volunteers that, that preside over the matters of the HOA. They're supposed to hold regular meetings, and there are typically staggered elections for the members of the board of directors, so that there isn't complete turnover of the board at any one given moment. And we do encourage homeowners to run for the board in order to participate in that, that self-governance and to have a meaningful say in terms of the decisions made by the board. We also have the HOA's attorney, their debt collectors. Homeowners aren't going to be interfacing with those players unless, there's some sort of rule violation or they're behind on their monthly assessments. And so when we're talking about the rules that apply to homeowners associations, we're talking about the covenants, conditions, and restrictions, CC&Rs. That lays out the homeowners association's right to collect monthly dues, and also sets forth the rules of the community. Those are recorded in the county clerk recorder's office. They are enforceable against the property just by virtue of that fact that they're recorded, right? Homeowners all are supposed to get a copy of their CC&Rs as part of the move-in package, and HOAs are also supposed to give an updated version of the CC&Rs, I believe, on a yearly basis. And so whenever you're looking to the CC&Rs to see whether there's some sort of unlawful conduct that's going on, it's always a good idea to make sure you're looking at the most recent version. We've also got the bylaws. Those are typically the rules of the road for elections, board meetings, and things like that. Also rules and regulations, where you can have a basketball hoop, whether or not you can, hang up your laundry to dry in your front yard, when your garage door is supposed to be closed and all that stuff. And you can also find a wealth of information about the laws that apply to HOAs at davis-sterling.com. And that website, it talks all about the Davis-Sterling Act, right, which are the provisions of the California Civil Code that govern homeowners associations. So if there's some sort of HOA governance issue, like the board is not holding regular meetings, or they're not granting access to books and records and meeting minutes and things like that, that homeowners are entitled to, if the HOA is not complying with their duties in that respect, then you could file a complaint with the California Attorney General's office. We've got a link there to the complaint portal there. Just keep in mind, the Attorney General is not necessarily going to investigate individual complaints, but it can be a good way to get the HOA to respond if they are, not responding to correspondence submitted on behalf of the homeowner. So when there's a rules violation, let's say there was a basketball hoop, right? Or, you installed some sort of improvement without obtaining a permit, right? Typically the CC&Rs are going to require a homeowner to obtain a permit from the HOA in order to move forward with the improvements, as an example. So if one of the HOA rules is violated and the HOA is going to fine the homeowner, they've got to send notice to the homeowner. That's got to go out at least 10 days before the hearing. And then there's a hearing held in executive session. Executive session means it's private. It's not open to all of the membership. It's a closed meeting. At the hearing, the homeowner is given the opportunity to submit evidence to make their case, to show why they should not, be subjected to fines or, discipline, why their, privileges should not be suspended. In some instances, homeowner privileges like access to the recreational areas can be suspended as a result of rules violations. So it's important for the homeowner to appear at the hearing and, submit what they have, make their case to the board, because failure to appear at the hearing is essentially like failing to respond to a complaint in court, right? It's treated like an admission that you agree with whatever the homeowners association is saying, and that, okay, they can take whatever disciplinary action they're saying that they're going to take. Really important for the homeowner to appear at the hearing and make their case. Within 15 days after the hearing, the board of directors sends out their decision. Typically, there's an opportunity for appeal. HOA assessments, those are the monthly dues that homeowners must pay to the HOA, right? Those are for, the common good of the homeowners association, maintaining those common areas, right, greenways and pools and, you know, the roadways in the HOA and things like that. All owners on title to the property are on the hook for the assessments. And the HOA's right to collect them is outlined in the CC&Rs. Always a good idea to check those out. Keep in mind that, of course, paying the HOA dues is just as important as paying the monthly mortgage, because if you fall behind on your HOA dues, the homeowner can be at risk of foreclosure. Just really quick overview of the types of assessments. Regular assessments, those are the regular monthly dues for the general maintenance and upkeep of the common areas. Those are determined annually. They can be increased up to 20% from the last year's regular assessments without a vote, right? Special assessments are for unexpected expenses or capital improvements. Like, let's say, for example, the HOA is installing decks on all of the units. Well, then the membership can be special assessed for those improvements. Special assessments that are greater than 5% of the annual budget must be approved by the membership. If the special assessment is less than 5% of the annual budget, it need not be submitted to the membership for a vote. Emergency assessments do not have a cap. They are imposed specifically in the context of an emergency, whether that is an extraordinary expense required by a court order or maintenance that's required because there's some sort of threat to safety, or an extraordinary expense that the board could not have reasonably foreseen. If the board is going to impose an emergency assessment because of some unforeseeable expense, they must adopt a resolution which specifically describes the emergency circumstances and why they could not have been foreseen. And that resolution must be distributed to the homeowners before the emergency assessment is collected. Here are some ways to keep informed about special assessments. Be aware of the HOA's maintenance practices. Talk to your neighbors about, when was the last time, certain things were improved. Just seeing what the HOA's practices are, identifying that, hey, these particular, this particular aspect of the community, it looks like it's in disrepair. It looks like it's going to need some improvement. That's a sign that, all right, well, the homeowners might get hit with a special assessment at some point. Also, always a good idea to sit in on the board meetings where the homeowners are allowed to attend those open meetings, so that they can get a sense of where the board is at in terms of any decision to impose a special assessment. All right, how can the HOA collect delinquent assessments? Well, if the assessments that are owed are less than $1,800 or 12 months, then the HOA can file a claim in court. They could record a lien against the property. They could send your account to collections. You might get calls from a debt collector, but the HOA cannot foreclose if the assessments are not 1,800 or 12 months behind, right? If the assessments are more than 1,800 or 12 months behind, then the HOA can use the foreclosure process to collect those delinquent assessments. The HOA does have to comply with the homeowner's Bill of Rights in order to use the non-judicial foreclosure process. So when the homeowner falls behind, the board has to adopt a resolution to record a lien against the property. The HOA must send the homeowner a notice that they are going to record a lien 30 days before the lien is recorded. After the lien is recorded, then the HOA, in compliance with the homeowner Bill of Rights, they've got to record a notice of default. They've got to wait for that 90-day period to elapse before they record a notice of sale. And then they can move forward with foreclosure 20 days after that notice of sale is recorded. In the context of HOA foreclosures, there is a right of redemption, right? That's in contrast with all the other foreclosures that we've talked about so far. No right of redemption. For example, if your home gets sent through non-judicial foreclosure by the mortgage lender, there would not be a right of redemption in that case. For HOA foreclosures, there's a 90-day period after the foreclosure in which the homeowner can pay off all of the assessments, the interest, the collection fees, and any reasonably necessary maintenance costs incurred by the new owner to keep the property in reasonable condition. All of those amounts would need to get repaid in order to redeem the property. Question?
So there is no right to redemption with a mortgage foreclosure in California?
Right. If you've got a non-judicial foreclosure by your mortgage lender, then there's not a right of redemption.
Is it one on the judicial foreclosure?
My understanding is that the rules for redemption may be different in judicial foreclosures. Again, keep in mind that the majority of foreclosures are happening through the non-judicial process.
Okay.
And so, all right, after the 90-day right of redemption period elapses, then a deed, the deed is recorded. That's when the foreclosure is complete. So again, when a homeowner falls into foreclosure with the HOA, there's time that the homeowner has to resolve the arrears. And so reach out to the HOA, ask for a payment plan. You can also just make payments as well. We'll talk a little bit more about the homeowner's right to, make payments in any amount in just a moment. So can the HOA limit participation in activities if you're delinquent? Yes, the HOA can limit privileges, but the HOA can't prevent a homeowner from coming in and out, accessing their unit, using the elevator, attending meetings, trash collection and utilities. The HOA cannot prevent the homeowner from accessing these facilities, entering and exiting their property, notwithstanding the homeowner is delinquent. If the homeowner has monetary penalties, like if there was a hearing because, the basketball hoop was out at the wrong time, or, there were unpermitted improvements, those fines cannot be collected through foreclosure. Only assessments. So when we're talking about that threshold, that $1,800 threshold, we're only talking about assessments, not interest, not late fees, not collection costs, just the assessments. And so the homeowner has a right to request a payment plan. Keep in mind, the HOA is not obligated to offer a plan, but the HOA must always accept any payment that the homeowner makes in any amount, right? And they must apply those payments to assessments first. Under California Civil Code Section 5655, Subdivision A, the court in the Huntington against Minor case determined that is an absolute duty. The homeowner association has no discretion whatsoever to refuse a payment made by the homeowner. It must be accepted. It must be applied to assessments. And so even if the homeowner can't afford the repayment plan offered by the association, you can always send a payment in. Would always suggest to send payments under these circumstances in some sort of certified mail, or overnight if we're coming down to the wire on the foreclosure timeline, just so that there's tracking, so that there's proof of that payment was sent and received. I already talked about this, so won't belabor it too much, but homeowners always have the right to make a payment, even if they can't afford the payment plan. The plan is absolutely not required to make a partial payment, and they must be applied to those assessments first. If the HOA, yes. So if we're talking about a mortgage lender, at the point when the homeowner is in default, the mortgage lender is not required to accept a partial payment. So the mortgage lender can demand payment in full before in order to reinstate the loan. HOAs must accept partial payments.
Question: if the mortgage lender doesn't have an acceleration clause in it, and they have to have an acceleration clause. Right. In other words, to make the whole thing due.
Yes, but that means that the whole loan becomes due upon default. That's typically what the acceleration clause says. In any case, if the loan is in default, a mortgage servicer is not legally required to accept a partial payment. They can demand payment in full. All right, keep in mind there are additional costs that the HOA can impose if a homeowner is behind. It can charge a 10% or $10 monthly late fee, as well as 12% interest. The HOA cannot charge for costs it did not incur. So, for example, if you're seeing debt collector fees on your HOA statement, but your account was never with the debt collector, you've only received correspondence directly from the HOA, that would be grounds to potentially dispute those costs. The HOA cannot charge for costs not actually incurred. If the homeowner does not agree with a charge imposed by the HOA, not a good idea to withhold payment, because that can result in the risk of foreclosure. So if there's some dispute, submitting the payment with a note that this payment is made under protest, reserving the right to dispute it later, better course of action than just withholding payment under protest. we generally would not advise homeowners to withhold payment to the HOA. Again, keep in mind, there's that pre-lien notice requirement that's required in the HOA foreclosure context 30 days before a lien is recorded, regardless of whether the HOA is going to move forward with foreclosure. Just the fact that they're going to record a lien requires that 30-day pre-lien notice. Under Diamond against Superior Court, the HOAs are held to strict compliance with the non-judicial foreclosure process. If there's any one error, right, then the whole process can be void and the HOA has to start back at square one. Few notes on property taxes. All right. So when a homeowner is behind on property taxes, this is probably the longest time frame under California law that homeowners have to avoid foreclosure. Property taxes cannot be foreclosed on until 5 years in default. The date of default for the purpose of property taxes is June 30th, following the year that the homeowner fell behind. So let's say that the fiscal year for when the homeowner fell behind is 2020 to 2021. So it's not until June 30th of 2021 that the homeowner is in default. So they've got 5 years from that point in which they can ask the county for a repayment plan to catch up. And so, always a good idea to apply for that repayment plan sooner rather than later, because of course those penalties can accrue very quickly when someone's behind on their property taxes. Interest as well gets tacked on. And so when a homeowner applies for a repayment plan with the county, they've got to make a 20% down payment. That's required by the Revenue and Taxation Code. It cannot be waived. So when considering whether a homeowner could afford a repayment plan, finding out what 20% of the total arrears are, it's going to give the homeowner a sense of, how much they're going to have to come up with to kickstart that repayment plan. Some cities and counties offer reinstatement assistance. There's the Alameda County anti-displacement program those funds can be used to reinstate property taxes. Alameda County anti-displacement can also be used for HOA dues and of course mortgages. So a little bit more to keep in mind. San Francisco help loans as well. It's a loan through the Mayor's Office of Housing and Community Development with terms that are quite favorable to the homeowner. And so if the homeowner lives in San Francisco, then they can apply for a help loan through the Mayor's Office of Housing and Community Development. Red flag to be aware of: if the property taxes are escrowed, delinquency can seriously impact the mortgage payments, right? And here's what I mean by that. So we've seen situations where the homeowner is paying their property taxes outside of the mortgage, right? They're paying directly. Suddenly, they're not paying their property taxes anymore. Like, for example, when we talked about PACE assessments earlier, there's this new expense that gets added into the property tax bill for PACE financed home improvements. The property taxes increase significantly. Now the homeowner can't pay the property taxes. Well, if the mortgage lender catches wind of that, then they might impose an escrow account to protect their security interest in the property. Because of course, if the property taxes go delinquent, that becomes a first lien, right, against the property and can therefore put the lender's security at risk. So the lender may impose an escrow account, at which point there will be a significant deficiency in that escrow account, right? Because if the homeowner hasn't paid their property taxes for several years and suddenly the mortgage servicer is collecting that on a monthly basis, you can see a really high bill. I've seen a monthly mortgage payment go up to $25,000 a month as a result of an escrow account being imposed after the property taxes were not paid for several years. Definitely something to be aware of. You can also apply for a reassessment exemption with the property tax collector if the property is reassessed, for its value after a transfer. If the transfer was exempt, for example, a transfer from parent to child, then the homeowner could apply for an exemption from that reassessment. Keep in mind there is a 3-year deadline to file that application for an exemption after the date of the transfer. So really important to get that exemption application and ASAP after the exempt transfer happens. For future property taxes, folks can apply for property tax postponement. Seniors and disabled folks and veterans may be also eligible for exemptions through the county where the property taxes can be reduced. But through the California State Controller's Office tax postponement program, homeowners who are seniors or disabled can apply for financial assistance. If they're determined to be eligible, the state controller will pay the property taxes, and those amounts paid by the controller will become a interest-bearing lien, a subordinate lien. Those amounts are not due unless the home is sold or otherwise, it's transferred, or a senior lien goes delinquent. So if the homeowner has a first mortgage and they fall behind on that, then the amounts postponed through the postponement program can become due. The applications are available for property tax postponement in September. The window is October to February. It's first come, first served. So if a homeowner wants to apply for property tax postponement, make sure to apply early to put the homeowner in the best position to be eligible. Talked a little bit about the Alameda County Anti-Displacement Program, right, offering financial assistance up to $30,000 for eligible homeowners. You can reach out to HERA for more information about that. There's also the California Mortgage Relief Program, and that program allows up to $80,000 in reinstatement assistance for homeowners who are behind on their mortgage or property taxes. And we've got a link there to the application as well. For the mortgage relief program, the homeowner does have to attest to some sort of COVID-19 financial hardship. And so you can learn a little bit more about what the nuances are in terms of what qualifies as a COVID-19 financial hardship on the mortgage relief program website. I know we're running a little bit over here, so I'll be quick. A reverse mortgage may be another option to avoid foreclosure. Not something we would necessarily recommend for everyone. It's a loan that converts the equity in the property into cash. And so it can, it typically, it pays off the outstanding debts against the property. If there's enough equity, the homeowner might get a lump sum cash payment or some sort of monthly installment. Homeowners, in order to be, and for a reverse mortgage, there are not monthly payments, right? That's the key difference between reverse mortgage and conventional mortgage. For a reverse mortgage, there aren't monthly payments, so the balance just grows and grows and grows over time. And when the homeowner no longer occupies the home, right, when they pass away or the home is transferred, then the loan becomes due. It can pose significant barriers to heirs inheriting the property because there's this significant debt against the home that has to be repaid when the homeowner passes away. And so if the homeowner is intent on, leaving the home to their children, things like that, then those can be reasons not to advise us for a reverse mortgage because of those limitations. But for folks who have a fixed income who are, not necessarily concerned about an inheritance, passing the property along, then it can be a great tool to avoid foreclosure if there are no other options. So of course, when the reverse mortgage gets taken out and pays off the conventional loan, those arrears are cured. They go away. All right, and home equity conversion mortgages, those are the reverse mortgages insured by the FHA. They come with specific rules that lenders have to follow. Foreclosure rescue scams. Sorry, and this is my last slide here, so we're finishing up. Foreclosure notices are public records. They're recorded in the clerk recorder's office, and anyone can look them up. Some counties restrict access, but for many counties, anyone could look up a home and see if it's in foreclosure. So oftentimes when folks fall into foreclosure, they'll start to receive an inundation of mail from folks saying, we'll save your house from foreclosure, or something like that. And so some red flags to keep in mind when that happens. Folks who are charging an upfront fee for services, making a sweeping promise to save the home. They'll definitely get you a loan modification even before they've looked at your situation, before they've looked at documents. that's a red flag. So if a homeowner is saying, should I work with this company? They say they'll get me a loan modification. I got to pay $5,000. It's illegal to charge upfront for loan modification services in the state of California. And so, when you see these factors in play, if the solicitor says, oh, just stop making your monthly mortgage payments, we'll take care of it for you, or make your mortgage payments to us, and, we'll take care of it from there. All of these signs are red flags. So if there's a foreclosure rescue scam afoot, report it to the CFPB, report it to the police and the attorney general, stop communication with the scammer, and, make sure that the homeowner is working with a HUD certified mortgage counselor or, another reputable nonprofit legal services group so that they can be set on the right path forward. All right, folks, thank you so much for joining us for this presentation. Housing and Economic Rights Advocates, we offer an array of legal services, general debt collection issues, medical debt, student loans, auto loans, things like that, debt collection defense, homeowners association issues, credit reporting, things showing up on the credit report that don't seem right, identity theft and the like. Credit building, and of course mortgages, special rights and protections for veterans and service members, and like I said, estate planning, setting up that will, trust, advanced healthcare directive, so that yes, so the only service that we charge for is on a sliding scale. That's estate planning. All of the other services that we provide for debt collection, mortgage, etc., all of those services are free. So the estate planning is the only service that HERA charges a fee for, and that is on a sliding scale. So to make it affordable. And you can learn more. We do not represent homeowners in probate. We do estate planning. So we help folks develop their, set up their will, set up their trust. But if there is a probate case, that is not a matter that HERA offers assistance with, unfortunately. Yeah, thank you for that clarification. Oh, I'm sorry to hear that. All right, so thank you again, everyone, for attending. And so is there a site, I just see this one question, is there a site specific you recommend to look up foreclosures? So to determine whether, I'm reading this question to mean, how to determine whether a home is in foreclosure. So again, foreclosure notices must be recorded in the county clerk recorder's office. And so that is our first go-to for looking at whether there's a notice of default, a notice of trustee sale. Look up the county's official recorded documents. And often there's an online search tool that you can use to look up whether there's a notice of default or, a notice of trustee sale or something like that against the property. Also, for the context of HOAs, if they've got a lien recorded, that will also be there as well. I think that those were all the questions. Yes, and if folks could just please take a moment to fill out this evaluation form that was dropped into the chat box. We always appreciate having feedback so that we can continue making our presentations even better. Thank you again so much for your time, folks, and I hope you have a great rest of your day. Stay safe out there.